All right, welcome. We got question 6 from 2009 July. It's a criminal procedure question. And let's go to the call to question and find out what it is we're being called upon to suppress. So what arguments might Dave raise under the United States Constitution? So they're not telling you specifically what amendment it is. This does cover 4th and 6th Amendment. Let's see here. In support of each of the following motions, and how are they likely to fare? Number 1, a motion to suppress the cocaine. Suppress cocaine. We've seen this call before. Generally a 4th Amendment. Okay, number 2, a motion to suppress Ted's statement. Well, it says, what arguments might Dave raise? Well, how could Dave suppress Ted's statement? The call of the question, if you notice that carefully, well, Ted's statement, you have no standing. Because you can't assert somebody else's constitutional rights. That's why then the call goes on to say, or in the alternative, for a separate trial. So that's a separate issue. So first we have suppress the statement, and the next thing you have separate trial. So those are two different issues in part 2. Number 3, a motion to discharge his present attorney and to substitute a new attorney in his place. Well, under the 6th Amendment, you do have the right to counsel of your choice. Not if they're appointed, though. If they appoint you a public defender, that's who you get. You don't have a right to keep switching out public defenders, but if you're going to retain counsel, you're going to pay for a private attorney, you have the right to represent the counsel of your choice, with some little tiny caveats. Okay, let's take it from the top. Polly, a uniformed police officer, observed a speeding car weaving in and out of traffic. Well, the fact that the car is speeding, you can seize them because a traffic stop is a seizure for any lawful purpose. For speeding, for running a stop sign, not having license plates or registration tags, you can stop it. So a traffic stop is a seizure, and Miranda warnings are not required during a seizure. It's a brief detention, and the inherent custodial nature of a traffic stop is, or of a custodial interrogation in the police station house questioning, it's not the same as when you're pulled over to the side of the road. Okay, with other people there. So violation of the vehicle code, there's a proper reason to stop. Polly pursued the car in her marked patrol vehicle, activated the blue and reds, pulled over, asked Dave, the driver, for his driver's license and car's registration, which is totally fine, both of which he handed to her. Although the documents appeared to be in order, Paul instructed Dave and his passenger, Ted, to stay there. Of course, they probably could have ordered them out of the car for no reason whatsoever, for any reason, or no reason whatsoever. You say, you guys get out of the car. But in order to pat them down and check for weapons, there has to be reasonable suspicion to believe, or at least a reason to believe, that they might be armed and dangerous. So far, we have nothing there. I'll be back in a second. Polly then walked to her patrol car to check for any outstanding arrest warrants against Dave. And for anyone who's ever been pulled over for a traffic violation, this is very common. It's all constitutional and nothing really wrong there. All we have right now is a seizure of the traffic stop, and that first paragraph is more or less background information to kind of set the stage of what's going to happen. When you do read a fact pattern slowly and carefully, the examiners rarely use words for no reason. Now, at times, not every sentence, not every word is going to be a case cracker. It's not going to present an issue. And the first paragraph, besides for the seizure, is just a background information for the examiners to kind of set the stage of what's going to happen next. All right? So don't beat yourself up if you don't find an issue in every sentence. As she was walking, Polly looked back. She's walking, she looks back, and saw that Ted appeared to be slipping something under his seat. Now, it's so important to use the words that they've given you. She's looking back and saw that Ted appeared to be slipping something under his seat. All right. Has Ted committed a crime? No. So there's no probable cause to believe that he's committed a crime or that a crime is occurring. Is this suspicious? It's right there on the border. And with a lot of criminal procedure questions on the bar exam, the examiners call upon you to discuss reasonable suspicion or probable cause or both. And I have a feeling we might have to do both here. Saw him to be, appeared to be slipping something under seat. So she clearly doesn't know what he's doing, but it might raise some suspicions. Polly returned to Dave's car, opened the passenger side door, looked under the seat, maybe that's plain view, and saw a paper lunch bag. So let's first go to where she appeared to see him something. So reasonable suspicion. We have the traffic stop, and the whole point for reasonable suspicion is specific and articulable facts that the officer can point to show that criminal activity may be afoot. And the point of this would be a part of a Terry stop based on reasonable suspicion. And what you can do is briefly investigate. And if you have reason to believe the person is armed, you can do a pat down of the outer clothing for weapons. Okay. That's what a Terry stop entails. So the traffic stop is valid. The Terry stop, because it seems to be a little suspicious, you could go either way on the issue. It doesn't really matter how you come out on it. Just discuss it, use the facts, what she saw, what the situation is, who are these people, what's going on here. So she saw a paper lunch bag. So she opens the door, looks under the seat. Well, is the item in plain view? And is she lawfully allowed to look there? And the second thing is it immediately apparent that it's contraband or evidence of a crime? She pulled the bag out, opened it, and found 5 small bindles of what she recognized as cocaine. She searched the car. Okay? So, plain view, it has to be immediately apparent without manipulating it. No manipulation. But of course, looked in the bag, so plain view is not going to apply. We're going to get to the heart of everything in a second here. Now, you need probable cause to search a car under the automobile exception. And clearly, there's no probable cause here. That's not even an issue, because was Ted committing a crime when she looked back and saw him, what appeared to be slipping something in the seat? We don't know if he was tying his shoes, stretching, moving something. There could be dozens of legitimate reasons or explanations, as just for good purposes or for unlawful purposes. And we don't know that. That's where the suspicion may come in. So you're going to discuss the reasonable suspicion and what she could have done. And also, during a traffic stop, if the officer believes that the people in the car, or the driver, or the passenger, whoever, is armed, then they can actually order them out of the car for any reason, by the way. And they can do a pat down of the outer clothing. And also, the officer can search the passenger compartment for a weapon, to look for a weapon. Now here, under Terry stop, the officer is not allowed to reach into the bag. So could have felt the bag to see if there was a gun. Like, is this a gun? Okay, it's not. That's it under Terry stop. Under the automobile exception, they can search the entire car, including the trunk and everything involved, with everything in the car, if they have probable cause. Clearly there's no probable cause, so you barely even scratch the surface of the automobile exception. And plain view, it wasn't in plain view because the officer had to look into the bag and it wasn't immediately apparent. So that is unconstitutional. Can't do that, can't do this, can't do that. Except for the seizure, everything else is unconstitutional. So, should the court suppress the cocaine? Absolutely. The first 2 paragraphs go to call 1. Back, there we go. Again, you would use the language that he appeared to be slipping something under his seat, which is suspicious. Can't look inside the bag, may be able to feel it. It's only for discovery of the weapons. Here she pulled out the cocaine, clearly inadmissible. So the first 2 paragraphs you'll notice go to call 1. All right. Polly arrested Dave and Ted and took them to the police station. Gave them Miranda warnings. Okay, perfect. Dave refused to answer any questions. So there's exercising his Miranda rights, whether it's right to counsel or right to remain silent. Ted, however, waived his rights and stated, "I did not know what was inside the bag or how it got in the car." Well, by saying that, you're kind of putting the blame a little. If you didn't, then he did. Because it's one of you two. There's only two of you in the car. Somebody put it there. "I did not see the bag before Dave and I got out of the car for lunch. We left the windows of the car open because of the heat." I have no idea what that sentence is in there for. Were they implying that someone probably threw it in the car? Well, no one's ever thrown 5 small bundles of cocaine in my car. I've never gotten that lucky. "So I did not see the bag until you stopped us. It was just lying there on the floor mat, so I put it under the seat to clear my feet." I don't understand why that's even relevant. Anyways, Ted's statements, because number 2 goes to a motion to suppress Ted's statement. Well, Dave's not the one who's arguing this. I'm sorry, Ted's not the one who's arguing about his statements. It's Dave. So he has no standing to contest. Besides, I don't think Ted did anything wrong. There's not even any reason for Ted to suppress the statement because he waived his Miranda rights and spoke. So Ted's statement's coming in, period, at the end. However, we're going to find out that they get charged jointly. So because it's a joint trial, that presents a little bit of a dilemma. And whenever you see jointly tried, you better be on the lookout for confrontation clause. And I'll explain why. The confrontation clause under the 6th Amendment says that a criminal defendant has a right to cross-examine any witness against him. And, which means the statement must be testimonial and the witness must be unavailable. Because if they were available, you get them on the stand, you cross-examine them, there wouldn't be a problem. But a testimonial statement is a statement that's going to prove past criminal conduct. Grand jury proceedings, police interrogation are the 2 main testimonials. So we have police interrogation, grand jury. Because the whole point of a grand jury is to prove past criminal conduct. So if you're a witness at a grand jury, it's testimonial. If you're answering questions during a police interrogation, that's also testimonial. And therefore, Ted must, in order to use the Ted statement against Dave, Ted must testify so that Dave can cross-examine him about the statements. Because essentially, Ted's kind of putting the blame on Ted. Ted's putting the blame on Dave by saying, "Hey, I don't know how they got there. I didn't put them there. Well, if you didn't put them there, then the jury's going to infer that Dave put it there. And it's also Dave's car." So there's 2 things we can do. It's got to be testimonial and unavailable. And here's how the confrontation clause works in a joint trial. There's defendant 1 and defendant 2. Both defendants have a 5th Amendment right, privilege against self-incrimination, which means they have the right not to take the stand. They don't have to testify if they don't want to. They also both have a 6th Amendment right to confront any witnesses against them. Well, if they're both in the same trial and the prosecution wants to use Ted's statements, they can use it against Ted. No problem there. Ted's statement can be used against Ted. But Ted's statement cannot be used against Dave unless Dave has the opportunity to cross-examine Ted. Well, what if Ted decides to exercise his 5th Amendment privilege against self-incrimination and not take the stand? Dave can't force Ted to testify. So now we have a clash between Dave's 6th Amendment right to confront Ted and Ted's 5th Amendment privilege not to testify. In that situation, what the court should do is either you don't admit the statement, period, whatsoever. Statement's not coming in. Number 2, you can redact the statement to eliminate any reference to Dave. Or 3, you separate the trials. Or you have separate trials, you don't try them jointly, you try them separately. So, separate trials, redact, and don't forget the redaction has to completely eliminate any reference to the other party. So Ted's statement cannot implicate Dave in any manner if Ted decides not to testify at this joint trial or not use it. So you either suppress the statement, you redact any reference to Dave, or you just order a separate trial. And separate trials are usually granted because the prosecution doesn't have to try all the defendants together, doesn't even have to try all the same charges at the same time. So a separate trial is when there might be prejudice, and because Ted's statement would cause prejudice to Dave, the court's likely going to grant the severance. In fact, it's probably better for them to do so, because this way Dave can cross-examine Ted and Ted will be forced to testify. Generally, Ted will get immunity to testify against Dave, or at least get some kind of deal, which he'll be impeached with, but Ted will be able to testify at Dave's trial and say, hey, it's all Dave. He's going to blame it all on Dave anyways. Dave's going to be able to cross-examine him, show that he's a liar, he took a deal, he ratted me out, it was his, so on and so forth, and let the jury decide who's telling the truth. That's how that works. So that's why we see being tried jointly, confrontation clause is the main issue. Okay. Final paragraph. Dave and Ted have been charged jointly with possession of cocaine. And when you see those words, that's when you know confrontation clause. Dave and Ted have each retained an attorney. Okay, so they've retained their own counsel. And that's good. They need their own counsel because there's a conflict of interest. They can't have the same attorney anyways. Right to counsel of your choice. We have retained counsel. Got it. So you're not freeloading off the system. Seems like these guys got some money, probably cocaine dealers. A week before trial. Notice that phrase, a week before trial. It's interesting, in another essay in 2014, it was the same thing. It was a week before trial, and the guy wanted to represent himself. Here, it's a week before trial. He's dissatisfied with his attorney and wants to discharge him in favor of a new attorney he hopes to select soon. Well, he doesn't. If you get a new attorney, it's going to take that attorney weeks, possibly months, to become familiar with this case, to be able to present a defense, to question the witness, to go through the file, to figure everything out. But we're 1 week from trial. So retain counsel. You have the right to choose your own counsel. We have 1 week before trial. This may cause prejudice on Ted, the court, the prosecution, the witnesses, but he does have a conflict with his attorney. It seems that Dave has become dissatisfied with his attorney. We don't know whether or not there's a conflict or he just doesn't like him or whatever the case is. So the court's going to weigh the fact of it's 1 week before trial. You want a new attorney. Are you doing this because there's a genuine conflict? Or are you doing this to screw around with the court, with the witnesses, and trying to prejudice the prosecution's case so that they can't prosecute you? And that's the discussion that goes on there. We don't have any facts to steer us one way or the other. He just wants to discharge him. He hopes to select a new attorney soon. It's going to take time to get familiar. And the question is whether that will prejudice everyone else, including the court, and the fact they have to reserve the jury room, they have to pick a jury. I mean, it's quite a process to have a jury trial. Okay, so it says, what arguments might Dave raise in support of each of the following motions? The motion to suppress the cocaine. Well, the original traffic stop was valid based on a violation of the vehicle code. The officer may or may not have had reasonable suspicion. No matter how you conclude on that, if they had reason to believe that either one of them or both of them were armed and dangerous for whatever reason, they could have done a pat down for weapons and even done a search of the passenger compartment, but they could not look inside the bag under their Terry stop. It would need to do only a plain feel. This was a search and would need to be supported by probable cause, and there was absolutely no probable cause to search. That's not even a question. It wasn't in plain view because the officer had to look inside the bag to figure it out. So it manipulated it. It wasn't in plain view. In terms of Ted's statements, no standing to contest Ted's statements. He was in custody, subject to Miranda. He waived his rights, and Dave has no say in what Ted says. Sixth Amendment confrontation clause. Either you're not going to use the statement, Ted's statement against Dave, if he doesn't, assuming Ted does not testify. You're going to redact any reference to Dave, or you're going to separate the trials, and therefore you can use it. That's probably what the court's going to go for. And it was testimonial because it was done in a police interrogation. Call 3 to discharge his present attorney and substitute a new attorney in his place. Because he has retained counsel, you have the right to private counsel of your own choosing, but it's 1 week before trial, and the court has to determine whether or not it's going to prejudice proceedings. Okay, and that is a wrap for question 6 from 2009 July, criminal procedure. There you go. Thanks a lot for listening.